I'd now like to introduce our next witness, Mark Sekula, Executive Vice President and Chief Lending Officer at Randolph Brooks Federal Credit Union. Mr. Sekula has 25 years of lending experience covering credit cards, mortgage, commercial, indirect lending, and collections. Mark and his team currently manage a $200 million commercial portfolio that includes SBA lending. In 2009, Randolph Brooks was recognized as the SBA Credit Union Lender of the Year. Mr. Sekula is testifying on behalf of the National Association of Federal Credit Unions. Welcome. You have 5 minutes to present your testimony.
Good morning, Chairman Walsh, Ranking Member Schrader, and members of the subcommittee. My name is Mark Sekula, and I am testifying today on behalf of NAFCU. I serve as the Executive Vice President and Chief Lending Officer for Randolph Brooks Federal Credit Union, headquartered in Live Oak, Texas. NAFCU and the entire credit union community appreciate the opportunity to participate in this discussion regarding the Dodd-Frank Act's impact on small business lending. Despite the fact that credit unions are already heavily regulated and were not the cause of the financial crisis, they are still within the regulatory reach of a number of provisions in the Dodd-Frank Act, including all credit unions being subject to the regulations and rulemaking of the Consumer Financial Protection Bureau, CFPB. This means credit unions like mine are facing a host of new compliance burdens and costs. As it relates to our business lending, the creation of the CFPB, the breadth of its power, and the costly regulations it will undoubtedly prescribe will impact how we allocate our resources for our membership. For example, Section 1071, which has not received much attention, creates a data collection system for small business lending, similar to the Home Mortgage Disclosure Act for financial institutions. Under Section 1071, every financial institution will need to inquire whether the applicant is a small business or women or minority owned. While well-intentioned in its own right, it is yet another compliance burden emerging from the Dodd-Frank. Furthermore, given that credit unions serve a defined field of membership, individual credit unions' information, in comparison to other lenders, could be skewed. Credit unions are chartered to serve their members. Thus, regulatory data collection that is intended for institutions that can serve anyone should not be imposed on credit unions. The financial institution must also maintain a record and report it to the CFPB. The information must be made public in accordance with the CFPB regulations. These provisions are effective on July 21st, yet implementing regulations will not be issued until after that date, leaving financial institutions with no compliance guidance on the effective date. While the CFPB has indicated that compliance will not be mandatory on July 21st, Congress should consider delaying the effective date of this provision until such time as implementing regulations take effect. The Dodd-Frank Act also includes a section 1100G, that says the CFPB must evaluate the impact that its actions have on small entities. We believe that credit unions meet the definition of a small entity. We would urge Congress to ensure that the CFPB abides by this congressionally mandated standard and does not try to narrow the definition of small entity in the future. The environment around regulatory reform has led regulators to make changes that impact credit unions and may cause them to tighten their lending to small business. At Randolph Brooks, our SBA loan volume has diminished in recent years, partly due to the economic downturn, but also because of the inconsistent nature of SBA examinations. On one hand, the SBA encourages granting small loans to qualifying businesses. Yet, on the other, the agency states that a lender status with SBA can be rescinded if these higher-risk loans default. The SBA provides a lender portal and a lender score from the SBA's credit risk assessment model. Our score is derived by averaging other lenders, mostly large 7A loans, with our small SBA Express loans. The blending of all lenders with varying portfolios to arrive at a score dilutes the true picture, as one cannot compare a small SBA unsecured working capital line of credit with a large SBA loan secured with commercial real estate. The two loans should not have the same evaluation process. If this does not change, it may eventually drive all small loans from the lender's portfolios. In addition to the SBA scoring problem, practices by other regulators have had an impact as well. Last year, the National Credit Union Administration, the NCUA, issued a rule to amend the agency's regulatory flexibility program known as RegFlex as it relates to business lending. The new rule requires a personal guarantee for all credit union member business loans, as MBLs. Unfortunately, this proposal will make credit union MBLs significantly less attractive to members. NAFCU believes and has told the NCUA that requiring a personal guarantee for all MBLs is unnecessary given the underwriting policies that RegFlex credit unions already have in place. Currently, there is a divide between Congress, the administration, and other policymakers that wish to spur lending and the regulators that oversee financial institutions. On the one hand, we sit in this hearing today discussing ways to encourage small business lending. On the other hand, regulators explicitly create barriers to new lending by regulation, the exam process, and implicitly warn credit unions against making any loans that may be deemed risky. Forced to choose between these two conflicting objectives, Randolph-Brooks must, of course, follow the directive of our regulators. In short, any congressional goal to promote lending will never be successful when the regulators are not on the same page. I thank you for the opportunity to appear before you today on behalf of NAFCU and would welcome any questions that you may have.